Good evening, ladies and gentlemen. It is a pleasure to have you today. I'm very glad, I'm very delighted to see you today. My name is Jonan Kanwano, I'm the team leader at Jonaki Holdings Limited. At Jonaki Holdings Limited, we offer credit. We do bridge financing. If you need money, you want to close that consignment, you want to buy that car, we can actually fund that by a certain percentage. If you're claiming a consignment, you want a facility to scale up your business, you want to travel, we get to support you with money, and then you pay gradually or in a given period of time that we shall agree on. Yes, so I usually look forward to discussing with you. Iron sharpens iron every Friday from 5:30 to 5:50 for 20 minutes. Talk about business, share with you of my experience, majorly lending, because that's what we do on a daily. We lend money. Jonaki Holdings Limited lends money. You can always check us out at www.jonakiholdings.com. But we also do business mentorship, especially those who want to start lending as well. In different parts of the country, we get to support them. Yes, so I really appreciate your time that you commit to come and watch live, and then thereafter, because after this we post this video on my YouTube channel at Jonan Kanwano, and there are a number of topics that I've talked about, especially in lending. So you can get to check out a number of topics I've talked about and acquaint yourself with wisdom. Bible says that in all you're getting, get understanding, get wisdom, and it shall make you successful, it shall uplift you, it shall establish you. So you need to get wisdom. Yes, so let me go straight to our today's topic. Our today's topic is court process and procedures for loan collection. I understand that as you give out the loan, there is something that you actually ask for. And I want to make it clear that the time that a client applies for a loan is not sure, especially for most of non-fraudsters, because you see, it is different case for a fraudster, because a fraudster sets out to come and apply for a loan with the intention to defraud. But for a person who applies for a loan with the intention to pay, it is clear that he wants to pay. But you see, things get out of hand not because they are intended to make them get out of hand, but probably because they got it wrong, or probably they didn't do their homework well, probably they didn't compute that something would go wrong, and that affects the payment eventually. So it is important to take note that, you see, understanding these things prior help you a lot, because you get to prepare yourself. The transaction which is bad does not become bad from the word go. Sometimes the client wants to pay, sometimes you want to close the deal very well, and he also, she promises to pay very well, but somewhere it gets out of hand. So if you've not prepared yourself, even the client, if she's not prepared herself or himself, you might end up in quagmire, you might end up in challenge. So I want to share with you 5 things that you have to look at. What procedures do you go through legally to foreclose on a land or foreclose on a car? But there are usually better options, because look, before you start thinking about foreclosing, remember it was not the intention of the client that he or she defaults. So it's important, first point, that you establish the intention of the client. If the intention of the client was to defraud, there are some things that he or she can actually hide from you. For example, if I have a collateral and I know it has an encumbrance, I hide it from the lender, that means I have a weird intention. And if the lender does not get to understand it, it might affect the lender. If I'm committing a collateral, that's inside of the client. Whether you know it or not, if you commit a collateral, and after giving you money, I establish that it has an encumbrance, I'll assume that you actually intended this thing, because you as the owner of the collateral, you need to do your own homework. Because you don't expect me as a lender, yet I'm obliged to do much more homework than the homework that you know about your property. So if I land on it, even if I've just dispersed the loan, I'll call back that loan right away. Why? Because I'll know that where I'm headed, probably I've been fleeced, or probably I have to put in effort to recover my money, because what I have committed on has an issue. and then I'll take it on the side of the borrower that they intentionally wanted to defraud me by committing a collateral that has an encumbrance. So the first thing to establish, or point number one, is let the mind of the lender and the borrower be clear. What is the intention? What are the interests of the lender and what are the interests of the borrower? The interest of the lender is to give out the money to the borrower. The interest of the borrower should be to actually use the money for what it is that they intended to use it for and be able to pay back principal and interest. So that should be very, very clear, and it should be stated out explicitly in the agreement that is drafted between the lender and the borrower. Point number one. Point number two, it is important that in case of any eventuality, if in case of any problem, it is important that before you run to court, you mediate. Establish a mediation procedure. It could be with the lender, it could be with the lender and the guarantor, it could be with the loans committee and the lender and the guarantor, or even it could be mediation in court. So mediate, because look, first of all, the lender is spending money, but also the borrower is spending money. And ultimately, if the lender has paperwork which is really explicit and procedurally correct, eventually the lender will have to pay. So why do you waste your time in court when actually you have an obligation, or you know you have an obligation to pay? I usually tell clients, you see, when you're coming for the money, you did not bring a lawyer. You did not involve some legal procedures. So why do you have to evoke legal procedures when it comes to time for your payment? Because it's not a sustainable way of running business. It's also not a sustainable way of handling payments. So I always encourage lenders and the borrowers have an amicable discussion, have a plausible agreement before you think about court. Court is not the best place to go to in case the business or the deal goes bad. Unless you cannot save the situation, unless you cannot agree on a few things, that's when you should opt for court. But I advise, if you can sort out your matter outside court, so be it. And it will help on the side of the lender as well as the borrower. If you don't do that, you're going to spend on both ends, but ultimately, if the lender has it right, you might actually eventually incur higher costs, plus the costs of the case by the lawyer, and eventually it will become a huge chunk of money that the lender actually has to pay. And if it goes the other way around, still on the side of the borrower, still there are high costs. So either way, whichever party loses, there are huge costs involved. But also, more so, by the time you get to that level, you don't want to look at each other eye to eye. And remember, when you're doing the transaction, I'd assume that probably you had a relationship, or you had a friendship, or probably, so long as there's a transaction, that means there's a relationship that has started between the lender and the borrower, which you'd want to further. So you wouldn't want to spoil such a relationship or a friendship that is in the making, or that is starting to exist between you and the company. Because, you see, that's not the end of the world. At the end of the day, as a borrower, you're going to need much more money. I've seen several cases. A client does not end it well, it's a back and forth, and before you know it, a client is coming back for money. And you see, if it didn't end well, eventually you might not be able to actually give that client the money that they need. And before you know it, the client might lose on a deal, might lose on a transaction, just because they didn't handle themselves well during the first transaction. So I pray and I hope that before you think about court, think about mediation. Point number 3. There are some companies, and I receive a number of inquiries from guys that I mentor and the guys that I walk this journey with. They ask some of the questions that, I do not have the money to actually put in the court process, back and forth. So there are two options that you can look at. The first option is that there are some firms, legal firms, that you can agree with. You show them the file, you show them the paperwork, especially if your paperwork is sound. If you did what you meant to do, and if you do not do what you meant to do, I advise that you look out for videos that I've done. They are on YouTube. on how you're meant to handle your loan processing, your loan process, from loan application to loan assessment to loan approval to loan collection and after sales services. But also it highlights key steps that you don't have to miss. They are very, very critical to make your file sellable, that in case you engage a lawyer and you don't have the money to give the lawyer, you can sit down and say, you know what, this client owes me probably 120 million, but when you follow up with this matter in court, because it's already in court, I'll probably give you 20% of what it is that you will collect. But if you see, if the file is not collectible, if it's not as easy, if you don't have all the requirements or the paperwork, the documents that you're meant to have on the file, it also becomes very cumbersome for the lawyer to follow through on that file. So I advise, if it's a good file, you can sit down with a lawyer or a legal firm and agree on the cut, a percentage, and they collect on it. Without you as a company injecting much more money, including the loan that you already issued, and it's backfiring. So it helps you a lot reducing the cost, especially if you want to concentrate, because sometimes the costs of the lawyers are really, really high. So you can agree if the file is good and you opt for that. The other option, or option number 2, is you engaging the legal firm. You agree on the cost and you entirely how to fund the cost. First, the cost of the legal firm for taking on the matter. 2 could be the cost for the courts, filing the case at court. You have to meet that cost. There's also the cost of back and forth with the client, because you have to be appearing in court as and when it is scheduled. So you have to pay those legal fees as and when, based on how the matter turns out. So that's the second option. So you have to look at those 2 options and choose which one is the best. But I usually advise that you opt for whichever option that favors you, but I found the first option to be plausible. Agree with the lawyer or a firm, and they follow through with the matter until they close on it. But one thing I've found, or the challenge I've found with that, leads me to point number 3. It is important that even if you give the lawyer the file, you actually have to follow through. You have to keep your eye, or you have to keep your nose on the matter. I have had issues with some legal firms. The firm goes and negotiates with the client, and the client gives them some money, and they just play around with the case, because on your end you've already committed some money, and the client also puts in money, and the lawyer just sleeps on the job. So it's important that even if you hand over the files to the lawyer or to the legal firm to handle on your behalf, it is important that you keep your nose there. You know what is happening, and if need be, let one of your staff be assigned on some of those matters to follow through, to know how far has this matter gone, to always update you. Especially I'm talking to the owner of the company, of the lending company. If you're the CEO, if you're the owner of the business, it is important that you take this matter at heart, because there is connivancy and you might end up losing the matter which you wouldn't have lost had you kept your nose in the case. So have interest, irrespective of your schedule, however busy you are. This is part of your work, and you're obliged to follow through and know what is happening on the other end of the coin. Point number 4. Have all the notes ready. Have all the notes ready. If it is first demand notice, have it ready, filed on the client's file. If it's second demand notice, have it ready and filed on the client's file. If it is a default notice, have it filed. If there are commitments by the client, kindly put them in writing. If a client is negotiating for something, if he's asking for any extension or help, have it in writing, not verbal, because at the end of the day, when it gets to court, it is evidence versus evidence. So you need to actually have this at hand. So I say this both on the side of the client or the borrower and the lender, because sometimes the lender is the one who is in wrong. The client is willing to pay. The client is very open-minded. The client is progressive, is actually willing to try as much as she or he can to pay, but the lender has interest in the property of the borrower. So in that case, I advise the clients as well, on the side of the clients, that make sure you have the receipts for whichever payments that you've made. Ask for those receipts. Sometimes there could be e-receipts. Keep them on your mail. You can always get them. Sometimes there could be hard copy receipts. Take screenshots and save them. In case of any eventuality, you have your defense that there is some amount of money that you actually paid. But also, if there are notices that you're served with, keep track of those notices. If it is the agreements that you signed with that company to borrow, keep a copy of that agreement. Because in the law, you're actually supposed to have that agreement. You have a copy of that agreement to know what it is that you actually signed. So keep those documents by yourself, that in case something happens, you have where to start from. But I also advise that as you're transacting, it shouldn't be intention of the client. Just because you've asked for money, it is your obligation to pay with interest. It is your obligation to pay with interest. I only think that you should retaliate or you should involve legal process if you know the intentions of the lender are not appropriate or they are not right. That's when you should actually fight for yourself as well and for your collateral as well. And then finally, it is important that in all these steps you involve your staff. If it is a company, involve your staff. Granted, you could have a lawyer, you could have a firm that is handling your matter, but involve your staff. But make sure as a lender that the files are sellable. I advise a book, usually to those that I mentor, Build to Sell, that if you read this book, it will guide you on what to do. That even if you're not building that business to sell, it will still be profitable because you will do things in the right way. And before you think about court, before you think about foreclosing, first engage. There's usually a better way of handling a transaction than court. At Jonaki Holdings, we usually say we do not want to clash with any client. It is actually the list of the things that we wish to encounter. Because most of our clients, we've got them through referrals. And issues of money, you actually bank on the trust. The client banks on the trust of the lender. The client comes easily if he's referred by another client than you advertising yourself. That's why it's important not to clash with any client if it's possible. But also, as a lender, it is important to note that it is not as easy. Some clients are really, really problematic. The guy comes to get your money and he very well knows that this is going to end up bitterly. But still then, the transaction ends up bitterly. So sometimes you cannot avoid it. That's why you have to clash with a few clients. But for most, we try our level best not to clash. And I advise any lender who is watching this video, try as much as you can not to clash with the clients, because you can only increase your clientele extremely, or you can increase the clients steadily if you do not clash with clients, or if you clash with as few clients as you can. Just know that this is a list of the results that I have at hand to resolve this matter to go to court. You should know it is a list of the matter. You've tried your level best, you've mediated, you've engaged the guarantor, you've engaged the employer if the client is employed, you've engaged all the parties before you actually involve court. Then before you know it, you end up with very, very good clients, and before you know it, your loan book is clear and you're clashing with as few clients or even zero clients. You're not clashing with any client at all. That's what I advise. But also, as I close this, I see our time is fast spent. As I close this, it's important to note that the loan is bad at the point of dispatch. If you don't do your homework, you as a lender, if you don't assess the borrower very well, that's how transactions end up in default. That's how you end up clashing with the client. So it's important that you actually assess the clients very well, and this will be helpful not only to you as a lender, but also to the client, because you'll know who can afford and who cannot. And for those who cannot afford, advise them, because that's how they end up losing their collaterals. They think you've denied them the money and probably you're a bad person, but you've actually saved them. That's how they end up in the hands of wrong lenders, and because they cannot afford to pay the facility, they lose their collaterals. So without further ado, I want to wish you a great evening. Thanks for watching. Have a blessed weekend. I look forward to having you next Friday from 5:30 to 5:50 as we get to share, as we get to polish, as we get to uplift one another. And kindly, as you learn these things, go out there and support someone, go out there and teach someone. You never know what that someone will help you. Even if it doesn't help, you know you'll have done your work to help. But also finally, learn one or two things. If you're learning, go and implement. If you don't, you'll have wasted your time and your data. You'll also have wasted my time. So I'm teaching these things so that you can actually ultimately apply them. I love you. You can always check out my YouTube channel and subscribe at Jonan Kanwanaho, but also our website www.jonakiholdings.com. So I wish you a great Friday and enjoy the rest of the weekend. God bless you. Most of these topics actually come from the people who learned and who watch these videos, and they say, you know what, I would like you to talk about this topic, and that's how I come through on some of the topics. I love you guys. Thanks for watching. Koleb, I can see you, Ainamani, and the rest of the guys. Blessings and have a blessed Friday and a great weekend. Bye bye.